morning, KOBC News. In today's broadcast, we're going to be discussing the case of Family Winemakers of California versus Jenkins. So in this case, that will be discussed Family Winemakers of California versus Jenkins. Out-of-state wineries contend that a Massachusetts wine distribution statute violates the Commerce Clause of the United States Constitution, which therefore deems it unconstitutional. The plaintiff, Family Winemakers of California, claims that the statute was created with the goal of giving a competitive advantage to Massachusetts wineries over the out-of-state wineries that produce 98% of the country's wine. This license allows them to sell their wines in Massachusetts in three ways: by shipping directly to consumers, through wholesaler distribution, and through retail distribution. Some of out-of-state wineries also meet this definition. Wines from small Massachusetts wineries compete with wines from large wineries, which Massachusetts has defined as those producing more than 30,000 gallons of grape wine annually. These large wineries must choose between relying upon wholesalers to distribute their wines in-state or applying for a large winery shipping license to sell directly to Massachusetts consumers. They cannot, by law, use both methods, and they cannot sell wines directly to retailers. This primary question is whether the Massachusetts statute substantially burdens interstate commerce. Alright folks, now we're going to hear from the federal representative.
So this case's issue deals mostly with the Commerce Clause. The Commerce Clause is meant to keep interstate trade fair, so violations of the clause come from discriminating laws and statutes. Discrimination under the Commerce Clause refers to when a state law or statute benefits in-state companies versus out-of-state groups. Plaintiffs have to prove the discrimination of the statute, and the state then has to prove whether they had a legitimate local purpose and why there aren't any non-discriminatory options. So this is typically very difficult for a state to prove, and usually state laws that change the conditions of competition in a market end up invalidated. However, the 21st Amendment should theoretically protect this statute, considering it allows states to strictly regulate alcohol, but it's all up to the courts to make the final decision.
The statute limits wine distribution rights based on wineries' total production of wine and the existing relationships with Massachusetts licensed wholesalers. This creates an undue burden on so-called large wineries and gives a competitive advantage to the small wineries. Small wineries that obtain a state license can use direct shipping to consumers, retailer distribution, and wholesaler distribution simultaneously. Being able to use these distribution methods simultaneously gives the small wineries a distinct competitive advantage in the marketplace. Combining these methods lowers smaller wineries' distribution costs because they can choose which method or combination of methods will be most cost-effective for a particular wine. The small wineries' use of retail distribution increases brand recognition and makes wholesaler distribution more likely. Direct shipping can similarly increase consumer demand for a particular wine, increasing the prospects for further retail sales and wholesaler distribution. Therefore, being able to use all these methods simultaneously gives them a distinct competitive advantage over the large wineries.
Massachusetts wineries have taken advantage of this situation. 27 out of 31 Massachusetts small wineries have obtained a license, instead only 26 out of 2,933 out-of-state small wineries have obtained such license. They also taken advantage of the combined distribution. In 2007, the first year of this statute, the 27% of the distribution has gone through wholesaling. Instead, 71% have taken advantage of the retail and direct shipment.
The 637 out-of-state wineries that qualified as large do not get the same advantages as the small Massachusetts wineries, as they are forced to choose between wholesaler distribution and direct shipping. Whether a large winery chooses wholesaler distribution or direct shipping, it causes a significant loss of potential profits, since using a single method results in the loss of consumer sales. Large wineries also face a disadvantage since they cannot reap the benefits of combined distribution methods, which offer higher sales and lower costs.
Alright guys, so now we're going to take a look at the press conference held by the Massachusetts state legislator as he defends the statute.
Alright, I don't understand why everybody's coming at us here at the Massachusetts General Court. Like, please hop off our backs, I'll explain everything, alright? It's clear that this statute has multiple non-discriminatory purposes, which are to ease direct shipment, to advance the three-tier system, and to make all small wineries, regardless of their location, more capable of competing, which would in turn provide Massachusetts consumers with greater choice of wine. The statute prevents the demise of small quality wineries who cannot afford the same distribution costs as the large established wine brands. It simply provides the small wineries a head start come the time to distribute their product. To all those saying that it helps Massachusetts wineries more than the rest of the US, there are far more small wineries throughout the rest of the country that could distribute their wine in Massachusetts just as easily. We admit that every winery located in Massachusetts is eligible to obtain our small winery license, but I assure you we are completely open to accepting all other small American wineries. There are almost 3,000 wineries outside of Massachusetts that qualify for our small winery license. The fact that only 26 of those 3,000 have acquired the license is no fault other than their own. Thank you.
That was great insight by the defendants. Now let's transition over to the townhouse as we're going to hear from the federal representative.
2, 1. What's interesting about the Massachusetts statute is how they define small wineries. Their definition of a small winery, is that it produces 30,000 gallons of wine annually, which sounds like a lot, but the wine industry actually has a very different standard. According to the wine industry and the Federal Trade Commission, a small winery would be labeled as a winery that produces 120,000 gallons or less per year. The industry also doesn't take into account the amount of fruit wine versus grape wine in these calculations. However, these standards aren't binding, they're just suggestions that the wine industry and the FTC operate from.
Massachusetts' own evidence shows that all out-of-state large wineries, besides the 5,100 largest ones, face a severe disadvantage due to this statute. The remaining wineries of the 670 so-called large wineries face the same difficulties in distributing their wines as the small wineries do. It is the smallest of the large wineries that suffer the most from this statute. Unlike the largest of the large wineries, these smaller large wineries can only distribute a handful of their higher volume wines through wholesalers. If they choose direct shipping, they are forced to terminate their existing relationships with wholesalers. This means that they will lose access to all of their retailers in Massachusetts, which is a crucial way for a smaller winery to build consumer awareness. This bill is not just regulating the few massive wineries that make up 90% of the market, but it is attacking the vast majority of mid-sized wineries that make up just a small percentage of the market. The statute does not help small wineries so much as it attacks any winery that is larger than the largest winery in Massachusetts.
As a matter of fact, these numbers fits perfectly the Massachusetts wine industry, because all of Massachusetts wineries fall into the 200 to 24,000 gallons cap. And so the only one that does not fall into such cap, it's a winery that produces also apple cider, and that explains the fruit exception that is contained in the Massachusetts statute.
Welcome back, everyone. We're getting breaking news from the courthouse. The court has sided in favor of the plaintiff, Family Winemakers of California. The court has come to the decision that the Massachusetts statute was in violation of the Commerce Clause. They found that the statute offered a clear competitive advantage to in-state wineries over out-of-state producers. The Massachusetts statute was also ruled to not be protected by the 21st Amendment as it violated interstate commerce law. Therefore, the regulations were unjust, even though states have the right to strictly regulate alcohol. This has been a decisive victory for out-of-state winemakers. That's all for this segment, folks. Thank you for tuning in to KOBC News.